Good evening, everyone. For those of you who know me, it will come as no surprise that I wrote about the Second Amendment and medical cannabis. I myself am a medical cannabis patient, and I also possess firearms for self-defense and for recreation. When I discovered that the constitutional rights of those similarly situated as myself were being infringed, I knew that it was my right and my responsibility to voice the concerns of medical cannabis patients nationwide. Before I jump into the specifics of my note, though, I would like to take a moment to recognize those who made this article possible. First and foremost, I'd like to thank my parents who are here today for their untiring support and confidence in me. I would like to thank Professor Daw for helping me tease out these complicated issues and come up with a great proposal that would have a real impact on the cannabis community. I would like to thank Heather Veronini for helping me mold from a rough outline a beautifully organized note. And last but not least, I would like to thank Dennis Perrone. Dennis passed away last Saturday. For those of you who do not know, Dennis was the father of the medical cannabis movement, which started right here in San Francisco during the AIDS epidemic in the 1980s. Without his fearless advocacy, I would not be here today. The title of my article, A Job for Congress, Medical Marijuana Patients Fight for Second Amendment Rights. The name of the case is Wilson v. Lynch. Back in 2000, the state of Nevada amended its constitution to provide its citizens with access to medical cannabis, following the lead of California, which provided access in 1996. In 2000, the Bureau of Alcohol, Tobacco, and Firearms drafted an interpretive rule entitled Open Letter to All Federal Firearms Licensees in response to the increasing number of states that were allowing medical marijuana and the resulting inquiries regarding medical marijuana's application to federal firearms laws. Currently in the United States, 29 states have medical marijuana laws. This does not include states with CBD-only laws for children with epilepsy, which would bring the total to 44 states. In the open letter, the ATF interpreted existing restrictions on the sale to and possession of firearms by unlawful users of controlled substances to include medical marijuana patients, regardless of whether their state had provided access. Following the release of the open letter, our plaintiff, Rowan Wilson, a Nevada medical marijuana patient, sought to purchase a firearm from a federally licensed firearms dealer. Given that the firearms dealer knew that Wilson possessed a medical marijuana card, consistent with the open letter, she was denied the sale. On appeal, the Ninth Circuit applied a two-part test to determine the constitutionality of the open letter and as it applied to Wilson. The court subsequently upheld that prohibition of sales of firearms from federally licensed firearms dealers to medical cannabis card holders. Even though the court found that Wilson was not using medical marijuana, the mere fact that she possessed a card was enough to restrict her purchase of firearms. Had Wilson actually used medical marijuana, her case would have been dismissed because in the seminal case, Heller versus DC, the United States Supreme Court held that the core right of the Second Amendment elevates above all other interests the rights of law-abiding, responsible citizens. The court could not find that medical marijuana patients are law-abiding because of the Supremacy Clause in the United States Constitution, which provides that when there's a conflict between state and federal laws, the courts must apply federal law. The result is that the Supremacy Clause stands as the most significant barrier to cannabis patients reclaiming their Second Amendment right. Because of the Supremacy Clause, the Ninth Circuit's analysis of the legality of marijuana does not take into account the fact that Wilson is immune under state law from criminal and civil penalties. Thus, until medical marijuana patients are deemed law-abiding or an exception is created, their Second Amendment challenges will always fail. Because the courts cannot provide an appropriate remedy, Congress or the executive branch are the proper institutions to provide relief. However, it is unlikely that the executive branch will act to fix this issue, especially because of Attorney General Jeff Sessions' animosity towards medical marijuana patients. Therefore, Congress bears the ultimate responsibility of protecting its constituents' Second Amendment rights. The legislation upon which I modeled this notes proposal is the Rohrabacher-Blumenauer Amendment, which is an amendment to the federal budget's appropriations bill that would prevent the Department of Justice from spending funds from the relevant appropriations bill to interfere with the state's implementation of medical marijuana laws. In 2014, the Rohrabacher-Blumenauer Amendment was passed for the first time and has since been consecutively renewed. In 2016, in the United States, in the case U.S. v. McIntosh, the Ninth Circuit was called upon again to determine the applicability of the Rohrabacher-Blumenauer Amendment to the prosecutions of various defendants indicted for violations of the Controlled Substances Act. Ultimately, the court upheld the Appropriations Amendment. There are two additional reasons why I decided to model my notes proposal after the Rohrabacher-Blumenauer Amendment. First is because the amendment would only be temporary, which would make it much easier to pass. And the Appropriations Amendment can be passed more quickly than can a federal statute. My notes proposal states that none of the funds made available in this act may be used by the Department of Justice with respect to any state, the District of Columbia, or any U.S. territory, allowing the use of medical marijuana to prevent medical marijuana patients in those jurisdictions from purchasing firearms from federally licensed firearms dealers, so long as the patient is in compliance with state medical marijuana and firearms laws. Fortunately, the proposed amendment would provide medical marijuana patients with the protections needed against the federal executive's overarching interpretive rule by returning the power to regulate firearms sales and possession to the states. The failure to destigmatize medical marijuana will have negative consequences for the wider medical marijuana community, specifically in licensing and social assistance programs, education, and healthcare protocols such as organ transplant lists. Therefore, any solution will require Congress to reconcile the tension between federal prohibition and state-sanctioned medical marijuana programs. The failure to protect the Second Amendment rights of patients could result in a slippery slope where patients are stripped of other constitutional rights because of the federal government's failure to recognize cannabis as a legitimate medicine. I leave you with this. Am I a law-abiding citizen? Well, I guess it depends on which government you ask. Thank you.